Nothing in this video should be regarded to constitute professional advice of any sort.
JLM can win this lawsuit based on what I've seen on the employment contract. Now, that doesn't mean her side's not going to come back and say that they breached the contract in some way. But based on what I've seen on the contract, JLM can win this. It doesn't mean they'll win in the court of public opinion, because people might be like, you're being mean, evil company. We love Hayley Paige. So we'll see. They could win the lawsuit and still lose in the court of public opinion.
Or Hayley Paige could win in an actual court of law.
When you trademark your name, when you have rights in your name and you sell those rights, though it feels shitty, the company's not wrong. And so it feels to me very much, as going through the Hayley Paige stuff, that she very much regrets the decision that she made. But it's a valid contract. She was paid for it. I don't know what you do with that.
Emily D. Baker asserts that the contract is a valid contract, and that JLM could win the lawsuit based on what she has seen in that employment contract. But is the contract really valid? Or more pertinently, is the contract enforceable by a court of law? While Emily does make some valid points, which we will explore later in this video, her analysis seems to miss some crucial points of concern. Courts will not enforce illegal contracts. Let's have a look if this contract, or some specific provisions in it, could potentially be illegal. It should be noted that even if the contract is legal, there may be other grounds upon which it may be unenforceable, but we won't get into those details in this particular video.
Know what Kat Von D's deal was when she sold her makeup brand, but I would imagine she sold the rights to her name. And this is different than Kat Von D in that Kat built her brand and then sold it after. This brand was built under the JLM umbrella always. So they hired her as an employee, signed the rights to her name, and she built her brand underneath them versus selling it. But it would be like if Jeffree Star sold Jeffree Star Cosmetics today, he couldn't go start a second Jeffree Star Cosmetics. He would sell it with his name. I mean, or maybe they would just want the formulas at this point.
Except the instances Emily mentioned include Taylor Swift and Prince, both recording artists. Emily indicates that she believes that Hayley Paige's contract is very similar to a recording industry contract. Other examples she discussed include Kat Von D and similar, which are in essence the sales of businesses. The crucial distinction is that none of these people are employees. Exercising reasonable diligence should include investigating whether or not various provisions contained in the employment contract contravene the specific jurisdiction's employment laws.
The employment agreement is still in effect as it was extended by JLM pursuant to a written agreement on July 15th, 2014, and pursuant to JLM's notice dated February 12th, 2019, in which JLM exercised its option to extend the term of the agreement for at least an additional 3 years. So February 2019 to February 2020, 21. So through at least the end of 2021, possibly 2022, exercise its option to extend the term of the agreement for at least 3 years. Pursuant to an amended agreement, Gutman's duties remain the same, except that she was also responsible for designing the Jim Helm, I think, bridal and occasions lines. See amended agreement. We'll pull the amended agreement. So this is saying that she was forced into a contract extension. In her video, she was saying she did not want to extend her contract because it was too one-sided. This is very similar to the music industry, where we see that in somebody like Kanye West's agreements, where it's like, no, you can say you want to be done, but we have the right to extend your contract without your permission. So we have the right. We've extended your contract. Show up and work. Show up and work. Show up and work. So this means they extended this contract. They had an option to extend the contract unilaterally and did so.
One very disconcerting provision Emily highlighted from the employment contract relates to the unilateral right to extend it. While the legislative protections, remedies, and case law may vary greatly from jurisdiction to jurisdiction, which means that such would not be binding upon a US court, a much closer comparison would be professional soccer players, where clubs have in the past attempted to enforce unilateral extension clauses. The Dispute Resolution Chamber for Sport in Switzerland declined to enforce unilateral extension provisions against professional players on the basis that these represented unreasonable restrictions to the players' freedom. If JLM only trademarked her name during the contract extension, and the contract extension itself is found to not be a valid contract, then JLM may not be entitled to the ownership rights over the trademarks. Even if JLM's trademark Paige's name before the contract extension, if it is an unreasonable restraint of trade, one would still have to at least consider whether the provision invalidates the entire contract, although a strong presumption in favor of severability does exist.
So it's not going to be well taken. Unfortunately, in law, she took the money, she signed the agreement, she sold the rights, and there's not a lot she's going to be able to do to undo that. The best I think she can hope for with this is that she is able to figure out what boundaries there are around this to move forward in designing in a way that doesn't directly compete with her employer, but they might be able to forestall her from competing. There is a non-compete in this, and I don't know how they force her to work from this. They might not be able to force her to work, but they can force her to not go and compete with them. And they might enforce a strict and long non-compete, meaning you cannot go design, and you cannot go design for someone else or in another way.
Emily shows part of the employment contract during her coffee and curse words stream. One of the paragraphs she seems to fail to highlight, but which still appears on the screen, reads as follows. In the event that the company files an application to register the trademark or trademarks, the employee agrees that for a period of 5 years following the termination of her employment, she shall not be identified to the trade or to the consuming public as the designer, and her role as designer shall not be used to promote the sale of any goods in competition with goods manufactured and sold by the company. This would presumably almost certainly include any appearances as a designer on Say Yes to the Dress, even if she designed under a different brand name, such as All That Glitters, as it could identify her as the designer to the trade and to the consuming public. Emily fails to even consider whether or not the 5-year global restraint of trade might constitute a violation of the Sherman Antitrust Act, and what possible impact that may have on the validity of the contract. She also fails to consider whether if making employment conditional upon agreeing to sell one's name might potentially make the contract unenforceable, particularly as the company does not only claim for itself the right to use the name for 2 years following the termination of employment, which would allow them to recoup costs already incurred during 2 more design seasons, but reserves for itself the right to trademark the name during such a period, which seems to be a provision that could be used in bad faith. If a designer made a name for themselves independently of the company's efforts after they had already left employment, or could be used to punish designers for leaving, possibly as an example to others, or potentially to sabotage the competitive efforts of a rival. Not only does the company claim for itself past work product during the term, but it also appears to restrict prospective work product during a time when the employee should not have any more common law obligations towards their ex-employer. Another somewhat disconcerting provision that appears on screen, but which Emily failed to consider, reads, Employee expressly acknowledges and agrees that all designs created prior to the execution of this contract were created as works for hire and are the exclusive property of the company. That is to say, not only does the company seek to restrict her output during the term and prospective work output, it also seems to seek to give the company the ability to quash any earlier designs, potentially in a manner which may be or maybe appear to be anti-competitive. That having been said, it is not known whether this is a standard provision in JLM contracts, and whether Paige had an actual meaningful opportunity to negotiate the provisions, whether or not she decided to make use of such an opportunity. This could include being allowed to use a pseudonym, etc. Based on the fact that the employment contract also claims the right to her married name, Gutman, it does not necessarily appear likely that she would have been allowed to use a nickname for her employment with the company. We do not draw any conclusions as to the legality of JLM's actions, as the facts are too unclear to form even a preliminary opinion, and that's exactly the point. That this is quite possibly not the open and shut case Emily and others in the YouTube law community appear to claim that it is.
Here, the company has said that this Instagram account was a business marketing Instagram account. It was started because of her employment contract with her JLM Couture. And then it goes into the fact that they had the password to it, that how much money they put into building it, that she had reached out to them and asked them to hire a manager for the account because it was getting very busy. And then at some point she kind of changed direction, and they have a bunch of exhibits posted to their motion that I will break down. But she started posting other content that wasn't the wedding content, and particularly sponsored content. And JLM's argument is that this sponsored content, I actually use this brand for some stuff, but that this sponsored content promotes a relationship between JLM Couture and between these other companies, but they were never given that opportunity. And she was selling sponsorships on her Instagram that has over 1 million followers, but that the business really owns this Instagram, and the business was the one that paid for it. Like, half of this motion for the temporary restraining order read like this: bitch, we made you. Bitch, we made you.
This seems to be where Emily's strongest arguments are. Even if some provisions of the employment contract are found to be unenforceable, it is still possible that the Instagram account, which appears to be the central issue here, may still belong to the company. Even without the trademark and/or exclusive worldwide right to license her name, the fact that JLM seems to have been responsible for the marketing strategy and seems to have laid out significant amounts of money could possibly still indicate that the Instagram account belongs to them, as the account seems to have been created during her employment and not after. One should consider the Instagram terms of service here as well, to see if any requirements for non-personal brands accounts have been complied with, if there are any. However, appropriate consideration should also be given to arguments advanced by Paige, including that the account seems to feature posts which are clearly personal in nature and feature her husband and potentially others who may not have consented to their likeness being used by the company for marketing purposes, possibly infringing on their publicity rights if Paige is not allowed to delete them, as she seems to claim. That is not to say that such arguments will be persuasive, as JLM's complaint seems to indicate that they informed Paige to refrain from posting any personal images and may only retain these in order to prove their case. Assuming that the Instagram account is determined to belong to the company, an employee has a common law duty not to act against the interests of the employer, using employer property without permission, and moreover derive income from that, here in the form of brand deals, would almost certainly be a violation of the duties that an employee owes to the employer, not only in terms of contract law, but in terms of employment law and common law. Based on Emily scrolling through the JLM complaint, it also appears that Hayley was required by contract to devote her full time and attention to JLM's business during business hours and was required not to engage in any business enterprise which could interfere with the performance of her duties. Here there is possibly substantial similarity with another example mentioned by Emily, namely that of the Bratz dolls, where the creator purportedly conceptualized the dolls while in the employment of Mattel.
So for those of you who are like, who in the world is this person? We will get into it. Let's get into Hayley Paige.
That would include me. We are not aware of any prior affiliations with any of the parties identified in this video, including Hayley Paige, JLM, or Emily D. Baker, other than the cursory interaction in the latter's chat, and only with regards to this case, as well as watching a few of her videos. She has a lovely, engaging presentation style. That doesn't mean I agree with her analysis.